of Mohammedan law. Yesterday we discussed what is gift. Again, I may repeat that gift as defined in section 123 of the Transport of Property Act is not applicable to a gift under Mohammedan because there is specific provision in section 123 that that section is not applicable to Mohammedan gift. So gift has been defined by various authors under the Mohammedan law. So what it says that gift, that is also known as hiba, that is hiba is defined as the transfer of the right of the property in the substance by one person to another without consideration. Consideration is yours, and delivery with possession. An unconditional transfer of property, any property, made immediately and without consideration. Transfer property made immediately and without any exchange or consideration by one person to another and accepted by or on behalf of the latter. That is gift. So there must be a declaration that the Mohammedan is making gift of the property, and the immediately property is transferred and followed by delivery, possession and acceptance of the gift. Now, sometimes you get a question that writes short note on Musa. What is Musa? Musa means the gift of an undivided part of a share. If a question comes, what is Musa? Musa means the gift of an undivided part of a share in a property. That is Musa. Gift of undivided share in the property is called Musa. A valid gift may be made where the subject object forms part of a thing, but if it is incapable of division. Undivided part of a share in a property which is not divisible, in such case there can be a valid gift. Musa means the gift of an undivided part or share in a property is called Musa. A valid gift may be made when in respect of undivided share in a property by a donor, by the person, when that property is incapable of division or is of such a nature that the same cannot be divided. That is such a nature incapable of division. So valid gift, undivided share in a property can be gifted. There can be a valid gift in respect of a Musa. Musa means if a gift is made in respect of an undivided share in a property, that is called Musa. So when such a gift is made, gift of Musa property is made, that is undivided share in the property is gifted. That is valid when that property is indivisible. That is cannot be divided or incapable of division, or is such a nature if got some kind of benefit or advantage can be derived from it only so long as it is undivided. So long that property is not undivided, the benefit can be obtained from that property. So that is undivided share, that is Musa. Gift may be made on undivided share of property, that is Musa, which is not capable of partition. Once it is capable of partition, then when undivided share in that property is gifted, in such case, that is not totally invalid. So, but it is an irregular gift, that is passive gift. A gift of an undivided share in property, which is capable of division. That property can be divided, can be conveniently partitioned. If that is made, then that is hit by doctrine of Musa. This is called doctrine of Musa. Undivided interest property in undivided share in the property or part of the property is gifted, that is called Musa. So this doctrine of Musa is applicable and it is valid, but it is an irregular gift. That is a facet gift. That is that, but the gift of an undivided share of any property which does not admit of partition is lawful. But the gift of an undivided share of any property, so what is facet? Facet but not void. It is an irregular gift, but that is not a void gift. Though the property can be partitioned, but the undivided share in the property is gifted. And that is Musa. The doctrine of Musa is applicable and it is not a valid gift, but it is a facet, irregular gift. But not to altogether void. That is not at all totally a void gift. A gift of a part of a thing which is capable of division is not valid unless the said part is divided off and separated from the property of donor. But thereafter, if it is separated, then that gift becomes valid. So the said part divided off or separated from the property of donor, but the gift of an undivided indivisible thing is valid. But in certain there is, that is this according to Hidayah says, what Hidayah's opinion is that undivided in share in the property which is subject to division, which is partitionable, which can be divided, if that is meant, that is totally void. But according to other authors, it is not a void, but it is a facet gift. Short illustration, suppose land cannot be given without the crop, then standing on it, nor a palm tree in bearing without its fruit, nor a house or vessel in which there is something belonging to the donor without its contents. Entire thing. So the doctrine of Musa is one arising out of the archaic state of society, that is, should be confined to the very narrow limits. Any defect due to Musa is cured by the donor taking. Once the donor takes possession by a part of that property, even if when that property is partiable, that is partitionable, that can be divisible, then that becomes definite share takes possession, then that becomes a valid gift. There are exceptions. That gift of an undivided share in property which is capable of division is invalid except in certain circumstances. But rule is that when the property is subject to division, is capable of division, and undivided share in the property is gifted, so thereby the specific share or the exact property could not be accepted, cannot be accepted by the donor. The donor cannot take possession of the exact share of the property because it has not been partitioned. But once that is the donor takes the possession of the share, undivided share in that property, then that gift become valid. But once if it is not taken, then that gift is a void gift. But there are exceptions. The gift of an undivided share in property, that is gift of Musa, which is capable of division, is invalid in following cases, except in following cases. In certain cases, where one co-heir make a gift of his share to another. Suppose two co-heirs are there. Two co-heirs. One co-heir makes gift of his share to the other co-heir. So in such case, though the property is capable of division, but it has not been partitioned, it has not been divided, and Musa is made, that is undivided share in the property is gifted, still it is a valid. This is an exception. Second, where the property admits of definite ascertainment of shares and is capable of separate enjoyment without division. There is certain property. When the property admits a definite ascertainment of share, that is a definite ascertainment of share is there and capable of enjoyment without division. Suppose gift of a definite share in immovable property, that is jomidari. Suppose 1/4 of the jomidari is gifted, or house 1/3, one half of the house is given, or shops is a gift of separate estate without separate and defined rates, and therefore the rule of Musa does not apply. In such case, the rule of Musa is not. Rule of Musa means what? When a property is divisible, and if a gift of that undivided share in that property is made, then that is void. This is the rule of according to Musa. But if that property cannot be divisible, is such a nature, it cannot be divided, then Musa principle will not be applicable, then such gift is valid. But though in following in certain cases, when one of the co-heir gifted a part of his share, a undivided share in the property to another co-heir, then Musa will not be applicable. Musa doctrine will not be applicable and the gift is valid. Similarly, where the property is such a nature that the share can be asserted and capable of separate enjoyment. Suppose if one house, well, the 50% house is given, two rooms are given. So it is such a nature that can be enjoyed even without separate of share. Third, where the gift of a share in jomidari or taluk. When a gift is made in a share of jomidari, it is no longer it is jomidari is there. That is previously there was share of jamidar or taluk that was valid, though it is a Musa principle is it is against Musa. According to Musa, it is to be treated void, but it is valid. Where the property is a freehold property, that is the large commercial town. Property is a large commercial town. Where the gift is of a share in a company, then the Musa will not be applicable. Then where it is made to the poor, or it is in the nature of sadak. Sadak means what? When gift is made in favor of mosque, that is sadak. Where it is made to the poor, or it is nature of a sadak, the gift of Musa is valid. So gift of Musa is invalid when if that property is divisible, but without division that has been given. But these exceptions are there. Where the right to receive separately a definite share of the rents of some undivided property is transferred. So the gift of an undivided share in any property capable of division is with exceptional means exceptions as discussed earlier is valid. So in such case, if in the following in the opposite circumstances, that is where one co-heir gives his property to another co-heir, or the property admits a definite ascertainment of share, and that can be enjoyed separately, where the gift is of a share of a jamidar or taluk, where the property is freehold property, that is large commercial town, where the gift is of a share in a company, where the gift is made to a poor, or it is in the nature of a sadak, because this is a poor person, very poor person, it has been gifted, still the Musa will not be applicable. So that is, this is then the where the right to receive separately a definite share of the rents of some undivided property, right to take a definite share of rent of an undivided property. So as I told, first exception, the gift of an undivided share in anything which does not admit a partition, or is of such a nature that it can be used better advantage of an undivided condition is valid. This is first exception. One or two or more co-sharers in any property may give his undivided share of the property to another co-sharer. So these are the exceptions. So now, gift of entire undivided share to two persons. Again, where the donor gives away by way of gift the entirety of her undivided share in estate in two persons jointly, the gift is not bad. When gift is made, the entire undivided share to two persons, that is not bad. The reason for the rule that the gift of an undivided share that in Musa is bad is to be found in the desire to avoid what has been described as confusion. So because Musa is only that is valid. The reason of the rule is only absent in a case where the donor gave out the entirety of her interest. Entire interest is given. Gift is executed in favor of more than one donee. This is a Mohammedan gave to his wife and child certain specific items of movable and immovable property by a valid executed gift deed, specifying therein the share to which each of the donee was entitled, and the donee accepted these and took joint possession. It has been held that the gift did not fall within the mischief of the doctrine of Musa. So you should understand doctrine of what is doctrine of Musa. You should understand, because if the property is divisible and if any undivided share in that property is gifted, that is not valid. But they are subject to exception. That is, but where the property is of a such a nature that is not divisible at all. In such case, Musa will not be applicable. Musa will not receive the gift. Shia law says a gift of an undivided share is valid even though it be a share in property capable of partition. That is, Musa principle is not applicable. So that is revocation of. Now whether a gift can be revoked. So until delivery of possession, a gift of his is not complete and is revocable. So once possession has been delivered, then gift cannot be revoked. After delivery possession, IBA cannot be revoked. Declaration, property is transferred and followed by delivery possession. The donee continues to enjoy the use and possess the power of disposal until it decrees. So that is why a gift once validly made under the Hanafi law is not revocable. In the Transfer of Property Act, whether a gift can be revoked, there is a provision that gift cannot be revoked or cancelled at the sweet will of the donor. But if there is a condition in the gift deed itself that on the happening of a particular condition, the gift can be cancelled. In such case, which doesn't depend upon the sweet will of the donor. If such condition happens, then the gift can be cancelled. So once a valid gift has been made under the Muhammadan law, that cannot be cancelled. But is not irrevocable in the following, where the donee is related to the donor within the prohibited degree. A gift once validly made under the Hanafi law is not revocable in the following circumstance. What is that? When the donee is related to the donor within the prohibited degree. Where the gift is made by a husband to his wife, that cannot be revoked. Or vice versa, or the wife has gifted property to the husband. Where the donee is dead and the subject matter of the gift has devolved on his or heirs. Then where the donor is dead, the right of revocation being personal one, his heirs have no such right. Where the thing given is lost or destroyed. Where the thing given has passed out of the donee's possession by gifts. Suppose the donee has already sold that property to another. That the gift cannot be revoked. Where the subject matter of the gift has altered the substance in the hands of the donee. So this is the mere partition of the subject matter of gift does not alter the nature of the property. So where the subject of the gift are increased in value and is so united as to inseparable from the subject matter of the gift, where the gift is for consideration. The donor has received something in exchange for it, that is hibabil iwas. Hibabil iwas and hibabil satwal iwas, that we will discuss. Where the gift is of a debt to the debtor, discharging the debtors from liability. Where the gift is sadak. Sadak means gift made in favor of mosque, that is sadak. Gift made in favor of mosque, that is called sadak. So after delivery possession in following, this gift cannot be cancelled, but that is revoked. When the gift is sadak, gift made on account of the natural love and affection may be revoked. But where it is burdened with something to be done by the donee, and the donee does not that is required by him, then the gift is revocable. The same thing. Suppose a property has been gifted with a condition that the donee will maintain the person. If that is some burden is there, if it does not disturb that burden, the gift can be revoked. Then how many kinds of gifts? Shia law says, according to Shia law, a gift in favor of parents or in favor of consanguinary relation cannot be revoked. Shia law says. Where the gift is to a stranger, it may be revoked at any time, so long as the subject of the gift is existent. So Shia law says, if it is gift is in favor of a stranger, then that can be revoked, so long the gift property subject of the gift is in existence. Causes such as alteration in the condition do not affect his revocability. So according to Shri, revocation is complete by a mere declaration without the sanction or decree of the court. Even by declaration that can be revoked. Limitation filing suit for challenging validity of a suit for challenging the validity of a gift must be filed within 3 years from the date of knowledge of the fact of gift. That is as per the limitation law is applicable, that is within 3 years. The suit having not been filed within a period of 3, the suit has rightly been to be barred, then its suit is barred by limitation. Now let us understand how many kinds of gifts are there. There are 3 kinds of gifts. One is hiba, hiba bil iwas, hiba bil shart wal iwas. Hiba shart ul iwas. What is hiba? Hiba means pure gift, only simple gift. It is unqualified and void of any consideration. And an absolute gift of property without consideration. It is hiba. Unqualified. Absolute transfer of property without consideration and accepted by the declaration with intention. So hiba bil iwas means a grant or gift for a consideration which is more in the nature of an exchange than a gift. It is not an exchange, but in lieu of something, some property is gifted, or in consideration of something, some property, when property is gifted, that is called hiba bil iwas. Hiba shart wal iwas. Hiba bil iwas. Iwas means consideration. Hiba shart ul iwas. Grant made on the condition that the donor or transferee should pay to the donor at some future time. When property is gifted with a condition that donor will pay something in future time or periodically, some determinate thing in return for the grant, that is called hiba shart wal iwas. So you should understand 3 types of gifts. One is hiba, that is a simple gift. Hiba bil iwas, hiba for consideration. Hiba shart wal iwas. So hiba is a pure gift without consideration, delivery, possession, and acceptance. That is a gift. That is pure good, simple gift. Hiba bil iwas. Hiba in lieu of consideration, on taking in consideration in exchange of something, though it is not an exchange. One thing for not. Some properties, something is given. In lieu of that, some property is given, gifted. Then that is called hiba bil iwas. Iwas means consideration. Hiba shart wal iwas, that iwas will be paid with a condition. So hiba shart wal iwas, that means when a grant made on the condition that the donee or the transferee should pay to the donor some property, some future, pay something in future, pay to the donor in future, or periodical payment, periodically, some determining thing in return of the grant. So the fundamental conception of hiba bil iwas or gift for an exchange as understood in the Mohammedan is that it is a transaction made up by 2 separate acts of donation. 2 separate acts of donation. That means of mutual or reciprocal gift. The donor will give some property. In lieu of that, the donor will give some property. Alternative, that is reciprocal gift of specific property between 2 persons. In exchange of gift, by reciprocal gift, in exchange of property, of specific property, if such a gift is made, that is called hiba bil iwas. Each of whom is alternatively donor and donee. First, he is a donor. One donor, donee, the donee will also become donor and donee to the donor. That is, in exchange or in lieu of something, in exchange of consideration, that is, which is made to the nature of an exchange, that a gift. That is, one person is gifting something, in exchange he is gifting something. So that is called hiba bil iwas. It does not include the case of a gift in consideration only for natural love and affection. That is not the only consideration is not in a gift, that is consideration, natural love and affection. But it is not there. Or service or favor rendered. Not all such a gift fall under the category of hiba bil iwas in its improper sense of sale. It is not a sale, but it is an ordinary gift subject to all the conditions to the validity. So that is unqualified and void of an consideration, where the donor makes an absolute gift of property, who is case that is of the property given is essential to the validity of the gift. So this is hiba bil iwas. What is the difference? The two kinds of hiba bilwas. That is, hiba bilwas means literally gift for an exchange. Another, if he is gifting property, the donor is also gifting some property. And it is of two kinds. According to the UAS means or exchange. Each of is not stipulated for at the time of the gift. In both kinds, there are two distinct acts. First, the original gift, and second, the UAS or exchange. But in the Hibabil UAS of India, there is only one act, the UAS or an exchange being involved in the contract of gift. In India, this Hibabil UAS is not strictly applicable. So here, this is gift in love. That is, the transaction which goes by the name Hibabil UAS in India is therefore in reality not a proper Hibabil UAS of either kind, but a sale. In India, it may be treated as a sale and has all the incident of latter contract. Accordingly, possession is not required to complete the transfer of it, though absolutely necessary in gift. Gift in lieu of dower debt. It was held by Allahabad High Court that an oral gift by a Mohammedan in lieu of dower debt was Hibabil UAS, because dower is leaving it, so that will be treated as Hibabil UAS. A Mohammedan husband cannot validly make an oral gift of immovable property to his wife in lieu of her dower debt. Such a transaction is not a true Hibabil UAS, but a sale. That will be treated like a sale, and so can be effected only by a registered instrument. That is, a transfer of property in lieu of an existing debt in cash would be transferred for a price. So, because in lieu of this dower debt, if somebody is transferring property, even if it is gift, that will be treated as a sale. Hibabul is validly made when there is a bona fide intention on the part of the donor to divest himself in present possession of the property and to confer it upon the donor. Under Mohammedan law, marriage is a contract of which dower is a consideration, and the transfer of land in lieu of dower is in the nature of a Hibabil UAS. You say Hibabil UAS. So, three kinds of gift: Hiba, Hibabil UAS, Hiba Sartil UAS. Hiba means gift pure and simple without consideration. In Hibabil UAS, gift for consideration in the nature of an exchange, but there is no express agreement for a return. Hibabil Sartil UAS means grant made on the condition that the donee should pay to the donee something, some determined thing in return. This is Hiba Sartul UAS. Second, delivery of possession condition essential for a valid gift. Similarly, Hibabil UAS also delivery of possession not essential. So, but Hibabil Sartul UAS delivery of possession is essential. Hiba is not a sale. Hibabil UAS is a contract of sale. Hiba Sartul UAS partakes the character of sale after possession is obtained by the donee. So in Hiba, Musa property capable of division is invalid. Musa is lawful under Hibabil UAS. Then Musa or property capable of division is invalid. So Hiba, it is not revocable except in few cases. Then in Hibabil UAS, it is irrevocable from the moment of its making. Similarly, Hiba Sartul UAS, it is irrevocable after the fulfillment of the specific one. Hibabil UAS is revocable. A Hibabil UAS is revocable in respect of the part for which there is no UAS or return. There is no UAS, but where the return is for the whole of the gift, irrespective of the amount of considered, it is irrevocable. Hiba Aryat. Aryat means what? When a rate or is transferred, is gifted, that is called Aryat. A Hiba is a transfer of ownership of the property without consideration. A Hibabul is a transfer of ownership for consideration. And Aryat is a loan for use of usufruct of the property. When usufruct of the property is given in gift, that is called without consideration, that is called Aryat, but does not involve transfer of ownership. A Hiba is not revocable except in certain cases. So this is, you should know what is Hiba, Hibabil UAS, Hiba Sartul UAS, and Aryat. Aryat means usufruct. Sadak means Sadak and Hiba. Again, you should know. It is made with the object of acquiring religious merit in the sight of the God. Sadak is when gift is made for religious purpose. That is called Sadak. Hiba, its motive is secular, made in maintenance of affection towards the donor. It is irrevocable after possession, as in case of Sartaj, it is irrevocable. It is revocable under certain circumstances. Hiba will, that is Hiba. Sada cannot be revocable. It is acceptance is not necessary by the donee. In case of Sadak, an acceptance of the gift expressed or implied by or on behalf of the donee is necessary. In case of Sadak, it can be made to two or more persons even if they are rich. Sadak. A gift made to two or more rich persons without specific of definite share is invaluable according to better opinion. So you should, in this is, first you should understand what is Musa, what is Hiba, what is Hiba will Hivas, Hiba will Sartable Hivas, in which cases this gift can be, the Hiba can be evoked. That is, that about that, there is a deathbed transaction. Deathbed transaction is Marjul Maut. Marjul Maut, you should know. Meaning, when a person suffering for marj, that is illness, is under apprehension of maut. Marj means illness, that is a disease. Apprehension of maut. He is said to suffering from marjul maut or death illness. So when a person is suffering from an illness and he is apprehending death because of such illness, then he is said to be suffering from marjul maut or death illness. So, what are the deathbed gifts essential? A gift made during death illness is subject to certain restrictions. A gift can be made in the deathbed is a person who is apprehending death in certain restrictions. A deathbed gift partakes of the nature of both the gift and legacy. The law of such transaction is also partly of will and partly of gift. It will be treated as partly of will and partly of gift, but it's basically being a gift. But it is a gift, must satisfy all the formalities. That is declaration that you will get the property, gifting, acceptance of the gift, delivery of possession. So what is that? A gift made during illness would be valid to the whole extent if the donor recovers his health and even in case of prolonged illness which has continued for more than a year. Provided, even if he recovers or if he continues prolonged illness, that gift will also be treated as valid. Provided the gift was made after 1 year and before the donor had become absolutely bedridden in state of dying. So here, limits of donor, he cannot make a gift of more than 1/3 of his property. This is not applicable to other kinds of gifts. Only in what? Deathbed gift, that is marjul maut, deathbed transaction, that is marjul maut. A gift cannot be made more than 1/3 property in favor of no heir, unless other heir give consent in favor of one heir, unless other heir give consent, similarly like will. The gift an heir made during death illness is altogether invalid unless the other heir consent to it. A gift made during death illness is subject to all the conditions and formalities necessary to constitute a gift in intra. That means delivery possession accepted. Death bed wakaf. Similarly, we'll discuss a different chapter, that is wakaf. A wakaf made on deathbed is subject to the same rule that govern the deathbed gift disposition, that is 1/3 of the unless the other heirs considers. Dower contracting during death illness, it is governed by the rules of meher, that is customary dower. That is marriage contracted on deathbed. A marriage contracted on deathbed is invalid, but if the person recovers from the malady, the consumption can cure the invalidity. This is what is called deathbed transaction by marjul maut. Marjul maut. So in this nutshell, we completed the chapter gift. Thank you.